of Edo State, and other judges here present, Your Excellencies, top government functionaries, Your Royal Highnesses, former Vice Chancellors of our great university and heads of other institutions, other principal officers of our great university, the inaugural lecturer and his family, the provosts, deans, and directors, professors emeriti, other esteemed scholars here seated, my lords, spiritual, greatest Uniben staff and students, invited guests, gentlemen of the press, distinguished ladies and gentlemen. We welcome you with all joy to the 360th Inaugural Lecture of the University of Benin. This lecture is to be delivered by a former Dean of the Faculty of Law, he is currently the center leader of SERI Uniben, an erudite, yes, clap please if you want to clap, thank you. An erudite professor of public law, Professor NATHANIEL INEGBEDION. Let me call his name again because I'm sure the applause clouded his name. Professor NATHANIEL INEGBEDION. Looks like I can't win on that. So the topic of today's lecture is Transformative Constitutionalism, the Utilitarian School, and Good Governance, the Nigerian Experience. May I now respectfully invite the representative of the Registrar of the University, who is the Deputy Registrar Senate Matters, Mrs. Comfort Ehigiato, to step forward to formally present the Vice Chancellor and the Vice Chancellor's entourage. Thank you.
Vice Chancellor, sir. I welcome you all to the 360th Inaugural Lecture in the series of this great university. The Registrar of the University, Mr. Ademola Bobola, is away on an official assignment outside the university and has requested me to represent him. He sends his greetings to you all. I am Comfort Inyegulena Eigiato, Deputy Registrar, Senate Matters. All courtesies duly extended. As stated by the PRO of this university, Dr. Mrs. Benedicta Ihanire, let me introduce the Vice Chancellor's procession. Today's procession is led by our determined, focused, transformational, and energetic Vice Chancellor. I therefore crave your indulgence to present to this great audience our own learned Sikh Vice Chancellor, Professor Edoba Omorige, who is represented here by the Deputy Vice Chancellor Academic, Professor V.O. Igbeneweka. Other principal officers, provosts, deans, and directors in his procession are as follows. Professor B.A. Ayinde, Deputy Vice Chancellor, Ekpoma Campus. The bursar is represented here by Mrs. P.N. Ojanero. The university librarian, Professor Mrs. Jane Abba. The Provost, College of Postgraduate Studies, Professor D.N. Izeko. Provost, College of Medical Sciences, Professor W.E. Sado. The Dean of Students, Professor F.O. Ekaise. The Host Dean, Faculty of Law, Professor Bright Bazoaye. Dean, Faculty of Agric, Professor C.O. Emokaru. Dean, Faculty of Arts, Professor O.B. Osadolo. Dean, School of Basic Clinical Sciences is represented by Professor Mrs. Caroline Omoti. Dean, School of Basic Medical Sciences is represented by Dr. U.O. Idemudia. Proton Dean, Faculty of Communication and Media Studies is represented by Professor Mrs. C.E. Obaje. Proton Dean, Faculty of Computing, Professor Mrs. V.V.N. Akukuma. Acting Dean, School of Dentistry is represented by Dr. B.E. Edetalen. Dean, Faculty of Education, Professor Elvin Sagbonlaho. Dean, Faculty of Engineering, Professor K.O. Ogbede. Dean, Faculty of Environmental Sciences, Professor Eigiato Irugbe Raphael. Dean, Faculty of Life Sciences, Professor T.O.T. Imobe. Dean, School of Medicine, Professor W. Osarogiagbon. Proton Dean, Faculty of Nursing Science, Professor F.U. Okafor. Dean, Faculty of Pharmacy, Professor Igodaro Igbe. Dean, Faculty of Physical Sciences, Professor J.I. Ubebu. Proton Dean, Faculty of Science Laboratory Technology, Professor J.O. Osaunese. Dean, Faculty of Vocational and Technical Education, Professor E.E. Uko Aviomo. Director, Center for Gender Studies, Professor Mrs. Lucy A. Okupon. Director, Intellectual Property and Technology Transfer, Professor S.E. Omonigo. Director, Tenford Center of Excellence in Aquaculture and Food Technology, Professor Mrs. Ijoma Obo. Director, Center for Sustainable Development Goals, Professor Mrs. F.I. Okungbowa. Director, University Advancement and Alumni Relations, Professor Eddie Eraigbe. Director, Advanced Digital Engineering Center, ADEC, Professor Aru S. Ewojiaye. Director, Institute of Childhood, Professor Mrs. Ayebo Sado. Director, Directorate of Research, Innovation and Development, Professor Mrs. N.F. Unuigbe. Director, Directorate of External Leakages and Internalization, Professor Mrs. A.E. Odiko. Director, Student Counseling and Career Services Center, Professor Mrs. O.N. Aihe. Director, Center for Continuing Legal Education, Professor Dennis Odigie. Director, UBIT, Professor S.D. Iyeke. Director, Step B Program, Professor Mrs. N. Kayode Ojo. Director, Nigerian Education Loan Fund, NEFON, Professor E.E. Imariagbe. Acting Director, Institute of Education, Dr. K. Imaswen. Acting Director, Institute of Public Admin and Health Services Management, Dr. John Osagai. Director, Consultancy Services Unit, Professor Aru O. Edokpia. Director, Center for Educational Technology, Dr. Mrs. N.B. Arawa. Acting Director, Center for Artificial Intelligence Development, Dr. E. Olaye. Director, Academic Planning, is represented by Dr. Mrs. O.M. Edeki. Leading the Vice Chancellor's procession is Mrs. Dupe Obayagmo, Senior Assistant Registrar, Senate Matters. I now have the honor and privilege to invite our dear Vice Chancellor to introduce the inaugural lecturer for today. Vice Chancellor, sir.
The Vice Chancellor, Professor Edoba Bright Omerege, SAN, is in Lagos right now for very urgent official assignment. He has asked me to give this apology. He has also asked me to represent him in this inaugural lecture. I will therefore deliver the address, and by the Vice Chancellor, Professor Edoba Bright Omerege, SAN, and the introduction of the lecturer, Professor NATHANIEL INEGBEDION, on the occasion of the 360th Inaugural Lecture Series of the University of Benin. Today, that is being delivered, 12th February 2026, at this Akin Deco Auditorium, University of Benin. We are very, very honored to have in our midst today Honorable Chief Judge of Edo State, Honorable Justice Daniel Kungbawa. We welcome you, sir. We are very, very happy. We have communicated with the Vice Chancellor that you are in the inaugural lecture. You're welcome, sir. I also like to very specially welcome Honorable Justice of Yahweh, I welcome Honorable Justice Aki Kidyeru. You're welcome, sir. Principal officers of the university, Provost, College of Postgraduate Studies, Provost, College of Medical Sciences, Deans of Faculties, Directors of Institutes, members of Council here present, Professors Emeriti and members of Senate, my Lord, spiritual and temporal, staff and great students of the University of Benin. I'd like to welcome Mr. Igodalo Imadegbelu, SAN. I welcome Mr. Kingsley Obamogie, SAN. I also very specially welcome our dear very Professor Eliho, former Provost, College of Education, Ekiadolo. Distinguished invited guests and friends of the university, gentlemen of the press, distinguished ladies and gentlemen. It is my pleasure to welcome you all to the 360th in the inaugural lecture series of the University of Benin. Today's lecture is the 7th to be delivered in the Department of Public Law. '15th to be delivered in the Faculty of Law. And by the grace of God, the 31st to be delivered in my tenure as Vice Chancellor, University of Benin. Ladies and gentlemen, It is my pleasure to introduce our lecturer for today. He is Professor NATHANIEL. Professor NATHANIEL INEGBEDION. The title of his lecture is Transformative Constitutionalism, the Utilitarian School, and the Good Governance, the Nigerian Experience. Professor NATHANIEL INEGBEDION was born on 9 February 1965 in Ekpoma, Edo State, to the family of Mr. and Mrs. J.A.O. INEGBEDION of blessed memory. He had his primary school education at Government Demonstration Primary School, Onitolo, Surulere, Lagos, where he obtained his first school living certificate in 1977. He attended Baptist Academy of Banikoro, Lagos, where he obtained his West African School certificate in 1982, as well as a higher school certificate in 1984. Professor INEGBEDION gained admission to the University of Jos to study law and graduated with a Bachelor of Laws degree, LL.B, in 1988. He proceeded to the Nigerian Law School, Lagos, where he obtained his professional qualification in law and was called to bar in 1989. He participated in the one-year mandatory National Youth Service Corps in Dr. G.I.J. Akigbe & Co. Legal Practitioners, Ebute Meta, Lagos, from 1989 to 1990. In his quest for more knowledge, Professor INEGBEDION obtained the Master of Law LL.B degree in 1992 and PhD Law in 2010, both from Ambrose Alli University, Ekpoma. Professor INEGBEDION possesses the following additional certifications. 1, Certificate in Human Rights in Africa, 2003, and Certificate on Special Economic Right, 2004, both from Faculty of Law, Pretoria University, South Africa. Number 2, Certificate of Completion of Social Standards Training of Trainers Workshop 2023, organized by the World Bank. Professor INEGBEDION started his academic career as an assistant lecturer in the then Benin State University, now Ambrose Alli University, Ekpoma, in 1990, and rose through the ranks to the position of senior lecturer. He thereafter transferred his services to the great University of Benin in 2003 as a senior lecturer in the Department of Public Law, Faculty of Law, and rose to the position of professor in 2013. He has held the following administrative positions within and outside the university. Acting head of Department Public Law, AAU Ekpoma, 1997 to 1998, 1999 to 2000, 2001 to 2003. Hall Warden, Geratin Mariri Hall of Residence, Ambrose Alli University Ekpoma, 2001 to 2002. Acting head of Department Public Law, University of Benin, 2004 to 2005, 2009 to 2011. Chairman, Nigerian Bar Association, Ekpoma Branch, 2009 to 2011. Member Council for Legal Education 2012 to 2015 and 2016 to 2019. Faculty representative, University of Benin Management Board of the Center for Part-Time Programs, July 2024 to 2025. 2014 to 2015, sorry. Congregation representative in Appointments and Promotion Board, Academic, 2015 to 2016 in University of Benin. Member, Appointments and Promotion Board, Academic Committee, University of Benin, 2016 to 2018. Chairman, Board of Engineering Subcommittee on Business Committee of Senate, University of Benin, 2021. Chairman, Appointments and Promotion Board, Academic Committee, University of Benin, 2023. Pioneer Director, African Institute of Management and Leadership, University of Benin, AFRIMA, 2014 to 2024 to 2025. Director, Center for Reproductive Health Innovation, SERI, 2024 to date. Member, the Governing Council Appeals and Disciplinary Committee, University of Benin, 2025 to date. Professor INEGBEDION belongs to the following professional bodies. Member, Nigerian Bar Association. Member, Nigerian Association of Law Teachers. Member, African Network of Constitutional Lawyers. Member, International Association of Law Schools. Member, Commonwealth Legal Education Association. Professor INEGBEDION is a recipient of the following awards and honors. Number one, Tertiary Education Trust Fund, TED Fund Award Research Grant, 2002. Tertiary Education Trust Fund, TED Fund Book Publication Award, 2004. Meritorious Service Award, Nasarawa State University, 2016. Professor INEGBEDION has served as a member of accreditation team and resource verification team to both NUC and the Council for Legal Education for several years to several universities in Nigeria. He has served as a external examiner assessor to some Nigerian universities and in South Africa. He is an external reviewer to Nigerian Current Law Review and a notary public of the Supreme Court of Nigeria. He has served as a member of Edo State Criminal Code Review Committee. He was also the Dean of Law, University of Benin, from 2016 to 2021. Professor INEGBEDION has successfully supervised 6 PhD theses, 20 master's theses, and numerous undergraduate projects. He has over 50 publications comprising chapters in books and articles in peer-reviewed journals, as well as 2 authored textbooks. Professor INEGBEDION has attended several local, national, and international conferences. Professor INEGBEDION hobbies include playing tennis and other recreational activities. He is a devout and a Knight of the Order of St. Lumba, Benin Metropolitan Council. He is happily married to barrister Mrs. Edna INEGBEDION. And the union is blessed with 5 great children. Ladies and gentlemen, it is my pleasure to invite Professor NATHANIEL INEGBEDION to deliver his lecture.
Mr. Vice Chancellor, sir, thank you very much for that very flowery introduction. Mr. Vice Chancellor, sir, today I deliver the 360th Inaugural Lecture Series of this great citadel of learning. The title of my lecture is Transformative Constitutionalism, the Utilitarian School and Good Governance, the Nigerian Experience. The lawyers in our midst here, the very learned friends and honorable judges that are present here, we clearly understand what I mean by the utilitarian school. Transformative constitutionalism, yes, they will have their own conceptions of what I mean by transformative constitutionalism. But let's forget about the big grammar. In sum, what I seek to do here is to interrogate our constitutions and see how they have been able to enthrone good governance over the years in the sense of making the people happy. And so, Mr. Vice Chancellor, sir, I have, in essence, compartmentalized my lecture into the following sub-themes, from the concept of transformative constitutionalism down to acknowledgement. When we talk of a transformative constitutionalism, what we have in mind is a process of constitutional enactment, its interpretation and enforcement that works for the people of Nigeria and hence enhances good governance. Otherwise, in the absence of that, the Constitution is meaningless. So that is where the concept of the utilitarian school comes in the sense that the utilitarian school says that for a law to be a good law, it must be able to increase the pleasure of the people and reduce their pain. Within the realm of constitutional law, it means that our constitutions must, in the text of the Constitution, its interpretation and enforcement must be able to promote pleasure and reduce pain for the generality of Nigerians. Otherwise, it defeats its very essence. Good governance is a nebulous term, but as used generally by donor agencies, it has 8 key indicators for you to have good governance. And that is, the people must participate in governance. Of the people, there must be consensus. It must be consensus oriented. There must be equity and inclusiveness. It must be effective and efficient, and there must be accountability. In sum, what we say here is that transformative constitutionalism, within the meaning as I've defined it, the utilitarian school all combined to ensure good governance. Consequently, I have looked at the features of the 1999 Constitution and extrapolated certain aspects of it, not all, that we believe textually are transformative if implemented. In this respect, I focused on its federal design, its fundamental objectives, which you know as Chapter 2, and of course, Chapter 4, its fundamental rights, because we believe that these are key to the transformative character of the Constitution, in the sense that when they work, the people are happy. First is the federal design. And here, we have submitted that the federal constitution can be traced back to 1954. But as it is presently constituted under the extant constitution, INEGBEDION and Omorege found that the federal constitution is lopsided in favor of the federal government, and so distorts what a federal constitution should be. And in the demonstration of its lopsidedness, I have looked at 2 examples that we can easily relate with. That is the infrastructure sector and the security sector. The graphical representation you see above there shows that the federal government is accountable to about 36,000 kilometers of federal roads out of a possible total of 200,000 kilometer roads. As meager as this may be, experience which each and every one of us here can relate to it, shows that these roads are very often in a state of disrepair. This is only so because the federal government is overwhelmed by its so many responsibilities as contained in the exclusive and concurrent lists of the legislative lists. We then looked at the security sector. Statistics show that currently, as of 2023, Nigeria has a total of 370,000 policemen with a population of 223 million. This comes to one policeman to 602 persons. Yet, the UN recommendation is that you have one policeman to 450 persons, thereby having a shortfall of 125,000. Is it then any wonder that Nigeria is bedeviled with security challenges? These states have tried to fill up the gap by setting up vigilantes all across the country. Yet, vigilantes conceptually means an illegal force that is not backed by law, when you look at the meaning of vigilantes. General criminal jurisdiction, even in Nigeria, rests with the states. Yet, you find that that general criminal jurisdiction is not backed by a state police. So you find federal police arresting somebody for committing a state crime. That general criminal jurisdiction is not currently backed by state prisons, even though there is a recent amendment that allows for states to establish prisons. But none has been able to do so. Yet, the general criminal jurisdiction is not backed by a full subnational justice system, as we noted in 2021, INEGBEDION 2021. Reasons have been advanced for the reluctance or the lack of political will of the federal government to support state police. But those reasons are neither here nor there, because the very reasons advanced, such as abuse of state police, the federal government is equally guilty of it. So, in INEGBEDION 2023 asserts that the solution is not prohibition of state police, but rather safeguards like legislative oversight, like judicial review by our laws, can address whatever concerns that we have against state police. The next slide depicts states' federal government tensions in the practice of federalism. I have examined 4 cases here as displayed above. 3 of those cases by the Supreme Court support the supremacy of states over federal government in respect of local government affairs. For instance, the second case, the town planning case, asserts that federal government has no business with town planning. That is a residual power belonging to the states. Similarly, the first case asserts the power of states to superintend over local government elections. And the third case rejects the power of the president to refuse allocation to states on the ground of local government interference. Yet, we had a rollback in the fourth case where the Supreme Court last 2 years ago, 2024, held that federal government can directly send money to local governments without reference to the states, thereby classically distorting the federal arrangement. And in total ignorance of the provisions of, well, I shouldn't say ignorance, in total disregard, that would be a more appropriate word, of the provisions of Section 162, subsection 6 of the Constitution. The National Assembly is now running helter-skelter make amendments to this provision to bring it in line with the Supreme Court decision. So, flowing from the last slide, what then is the role of judiciary in transformative constitutionalism? Given that the expression has been defined to mean the process of constitutional enactment, interpretation, and enforcement, it goes without saying, the courts, particularly the Supreme Court, plays a very big role in the process. And in this respect, we want to focus on the court's attitude to justiciability and standing. Here, we do a comparative study with India, South Africa, on these two issues. Chapter 2, as the lawyers are very familiar with, is the one that readily comes to mind when we speak of non-justiciability. And that chapter 2, when you look at the text, is meant to enthrone an egalitarian society and promote national unity. It is that chapter that the Constitution says, at least when you read Section 6, subsection 6, paragraph C in isolation, that the Constitution says that cannot be enforced. We have done a comparative analysis with Republic of South Africa, Tunisia, Egypt, Uganda, who, rather than adopt the bifurcation or division of rights, rather have adopted the indivisibility of these rights. In other words, you cannot really distinguish between one right or the other. They are all the same. The fundamental objectives talks about economic development, job creation, free education, quality health care, judicial independence, and Section 13, which I consider very profound, requires that all organs of government, that is the executive, the legislature, and the judiciary, must conform to, observe, and apply the provisions of this chapter. I have ruminated over this provision over the years in the light of the court's reluctance to litigate, to allow for the litigation of Chapter 2 rights. What do we mean by conform to, observe, and apply if the court say that Chapter 2 rights are justiciable, are not justiciable? The non-justiciability courts, like I said, in effect, distinguishes rights that are enforceable and those that are not enforceable. Even though Chapter 2 does not call them rights, stricto sensu, in the real sense, but when you examine the definition of rights jurisprudentially, apologies to my host, who is a guru in this area, you will discover it includes, rights will include an obligation. And Chapter 2 are obligatory rights. So in that sense, you can refer to them as rights. But our courts have said that they are not justiciable. And this decision flows from two cases which are shown above there, Okoje's case and against Attorney General of Lagos State, and of course, Attorney General of Borno State and Adamu. What then are the regional trends, given the state of our law here? Like I said, South Africa does not bifurcate these rights. All rights in South Africa, the rights that are not justiciable in Nigeria, Chapter 2 rights are justiciable in South Africa. This includes right to clean environment. Same in Tunisia, there is no distinction. Under the 2014 Tunisian constitution, you find the same in Egypt, under the 2014 Egyptian constitution. You find the same under Article 45 of the Ugandan constitution. We must understand the context of the transformative character of the South African constitution. This is because the constitution was just emerging from a period of apartheid. So in that sense, they were in a hurry to catch up and make sure that rights like clean environment, housing, health, education were all made rights you could litigate and enforce. They did not just stop that. INEGBEDION 2008 observed that they even deconstructed the local standing myth by saying that any person can enforce these rights, whether it's personally affected or not. We have done 3 case studies of the position in South Africa to compare with Nigeria. And we discovered that the first case, Minister of Health and Treatment Action Campaign, with apologies to the provost of the College of Medicine, here cited, the court there held that a pregnant woman has a right to antiretroviral drug, nevirapine, in order to prevent mother-to-child intrapartum transmission. That is, in order to prevent HIV transmission at pregnancy before birth. And said that denial of that drug was a denial of right to health and also denial of children's right to basic health. As things currently stand in Nigeria, under a constitutional design, that cannot happen. The second case similarly told the line of the Good Boom case. The third case is a case of housing, where the court again said that the applicants had a right to housing. This is a case where 510 children and 390 adults were left without housing. They were exposed to the harsh elements of the weather. The ramshackle structure where they previously stayed was demolished by government and so exposed to the harsh weather. This story should resonate with us in the light of frequent demolitions that take place in Nigeria without remedy. A good example, of course, will be the Maroko demolitions, where you now have, those of you who are familiar with Lagos, where the elites now live, that has been transformed to Lekki, where thousands were rendered homeless. If that were to happen in South Africa, going by this case, the court would declare it a nullity. Of course, we also have experience here with the University of Benin, where residents in the middle of the night found that over their heads, their residence in the GRA had been demolished by government. That case is still rather sneaking its way to the Supreme Court up to now. Now, the Indian approach is very interesting. The Indian non-justiciability clause is similar with the Nigerian own. India also bifurcates rights that are justiciable and those that are not justiciable. But they have found a way around it. India has been able to tie the enjoyment of fundamental rights that are justiciable with social and economic rights that are not justiciable, by saying that the lack of enjoyment of one concomitantly also means the lack of enjoyment of the other one. In fact, in the two cases considered, the Indian courts held that implicit in the right to life is the right to education. That if a person is denied the right to education, he cannot claim to enjoy the right to life. Section 13, earlier referred to, has always been the subject of judicial exposition. In the two cases considered above here, in the first one, the Supreme Court held that the non-justiciability clause is neither total nor sacrosanct, meaning that in appropriate cases, it could be set aside. And in the second case involving Anache, the court held that Chapter 2 is not a toothless bulldog, which could only bark but cannot bite. INEGBEDION and Amorege argued that the section 13 earlier referred to could actually be used to advance the enforcement of Chapter 2 rights. Sorry, INEGBEDION and Okunrobo. INEGBEDION and Okunrobo. What then is the breakthrough in this area? At least in the right to education. The right to education. The courts now recognize that right to education is justiciable, even though it is in Chapter 2. The courts have been able to do this, even as recently as October 2025, on the premise that when you combine Section 66C, Section 13, and universal basic education right, the argument that the right to education is not justiciable no longer holds water. It is now justiciable. That takes me to the second leg of the submission, which is standing to sue. Standing to sue, as you all know, that unless you are personally affected by a matter, you cannot seek redress in court. This is shown in the following cases, shown on the three cases shown on the board. However, recently, and as recent as 2019, the courts adopting the liberal approach have held that in appropriate cases, the standing to sue could be liberalized to allow those who are not personally affected to sue. But such cases are very narrow. You find them in the environmental pollution cases. And in 2010, it was held to also include cases where you have constitutional violations. But then, there was a relapse in 2023 and 2024, where the court held, referring to even the oil pollution watch case in the former slide, that in spite of the decision in that case liberalizing the right to sue, that unless a person is personally affected, he cannot initiate any action. The problem here could be traced partly to the 2009 Fundamental Rights Enforcement Procedure Rules, which provide for public interest litigation in the enforcement of fundamental rights of Chapter 4. Those rules, the drafting of those rules was largely influenced by the human rights movement, who clamored for it. But they forgot that the countries from which they were inspired, public interest litigation was an integral part of their constitution, like the South African constitution. It is not so with Nigeria. Section 46(1) clearly says that you cannot, unless you are personally affected by a violation of human rights, fundamental rights, you cannot litigate it. You must. So then you have a conflict between Section 46 and the Fundamental Rights Enforcement Procedure Rules that allow for public interest litigation in the enforcement of human rights. INEGBEDION 2008 argued that in the light of the supremacy clause in the Constitution, Section 46, subsection 1, does not permit public interest litigation in the enforcement of human rights. So, all said, you have a number of unresolved constitutional clarity issues. One is the problem with local government. Two, the over-concentration of powers in the federal government. And three, of course, is the 2024 local government autonomy case, which shows that the decision of the Supreme Court in that case has clearly not resolved the problem. Because since then, states have not implemented that decision of the Supreme Court. There is no evidence that the old practice of meddling with local government funds has ceased. It still continues. So, Mr. Vice Chancellor, sir, please permit me to now look at the intersection between transformative constitutionalism and good governance. Mr. Vice Chancellor, sir, we argue here that constitutions matter for economic performance. And here we contend that without a good constitution, you can't have a good economy. And so the people are both bound to suffer. Without a transformative constitution, you can't have a good economy. So you have then, of course, without a good economy, you have a people who may sabotage any efforts to make the economy run. So you are foisted with a situation which we have described in NATHANIEL 2019 as constitutional irreverence. That is to say, a lack of respect for the Constitution. Lack of respect for the Constitution. And that is what essentially is playing itself out, not just in our political sector, but in our security sector. In this sense, I wish to focus on the political arena. Constitutional irreverence manifests itself, for instance, in reckless and incessant cross-carpeting happening in a National Assembly and the state legislative houses without consequences, even when there is no division in the political party. The second example is manipulation of the local government system. Another example of constitutional irreverence, in spite of what I thought was a clear provision of the Constitution. So how does this concern transformative constitutionalism relate with Human Development Index, good governance? Good governance. That's where we come up with the Human Development Index. To provide a snippet that without a transformative constitution, we can't have a good HDI. The HDI measures a country's achievements in health, education, and standard of living. Here, we have compared the HDI of a basket of 5 countries, as shown in tabular form above there, for 2021, 2022, and 2023. And in the three tables considered there, you see that can I have some technical assistance here, please? Technical assistance, please. Something else is showing on my screen. Okay. Mhm. And this is not going. How will I slide it? I can slide it with this one. Just let me see. So that in the three tables considered, you see that Nigeria consistently comes last. Last. And the other countries there are countries that have demonstrated treats human rights as indivisible. There is no separation between the chapter 2 rights and chapter 4 rights. All are put in the same category. What can be the reason for Nigeria consistently coming last? It's simple. Nigeria's refusal to protect the fundamental objectives and its prevarication on local standing in human rights. That is not enough. The non-justiciability even has a devastating impact on Nigeria's poverty levels. Mr. Vice Chancellor, sir, the poverty crisis in Nigeria currently stands as at 2024 stands at 63%, meaning that you have 133 million people that are multi-dimensionally poor. I'm not the one saying so. I got the statistics from the Senior Special Assistant to the President on SDG goals. Consequently, as observed by INEGBEDION and Umoro 2021, you cannot extricate the non-justiciability clause to Nigeria's poor record with meeting its SDG goals, one of which, of course, is elimination of poverty. Therefore, there is a nexus between the HDI of a country and protection of its fundamental objectives and its human rights. What is the path forward? Mr. Vice Chancellor, sir, my lords, we submit that good as the public interest litigation may be, it cannot work unless Section 46, Subsection 1 is amended, and we call for its amendment. We also call for a more judicial activist role in using Section 13 of the Constitution, which requires the organs of government, including the executive, legislative, and judiciary, to observe, conform, and apply the fundamental objectives and directive principles of state policy. We recommend that the constitutions of the position in South Africa, India, and even Tunisia should be adopted in the sense that human rights should be treated as indivisible. We recommend that the country should set up a specialized constitutional court as a final court solely for the constitutional interpretations as key driver of constitutional transformation. A lot of efforts have been made in the past, but it has come to nothing. South Africa was able to transform, was able to apply the non-justiciability clause because they have a constitutional court that is superior to its Supreme Court. So we need a constitutional court in this direction. And lastly, there must be a clear demarcation of status of local governments, and the federal government in any classical federation. Though I concede that there is no such thing as a true federalism. A federal government is determined by the socio-political experiences. A federal constitution is determined by the socio-political experiences the people find itself. Indeed, there are some constitutions in this world, like Spain, Barcelona, Spain, Spain, Britain, where you cannot actually determine whether the constitution is a federal one or a unitary one, because some of the regions are semi-autonomous, even though in actual fact their constitutions are unitary, including Ghana. Ghana has a unitary constitution, but it also has features of a federal system because it has regions. So there is really no such thing as an ideal federal system. But in all known systems, the states control local government, because local government is meant for local affairs. The federal government shouldn't have any business with local government. So there should be a clear delineation of a two-tier federal structure, even with state constitutions, which specify state-local government relationship. Conclusion. I have interrogated the transformative character of the Constitution of the Federal Republic of Nigeria in terms of a long-term goal of constitutional enactment, interpretation, and implementation. Such is bound to positively reflect on the standard of living of the people. The table of countries compares does not put Nigeria in that light. Where then lies the problem? Obviously, there's a nexus between the standard of living and the transformative goals of the Constitution as reflected in its design. Its federal design and scope of its human rights are very central in this respect, and all go a long way in ensuring the greatest happiness for the greatest number and promoting pleasure over pain. Acknowledgements. I must thank Almighty God for giving me the opportunity to present this inaugural lecture today. That I'm alive today to do so if by sheer divine providence. Several times I have passed through the jaws of death, but God has preserved me. I give him the glory. I thank my late parents for the discipline instilled in me and in the other 14 children, with me in the 11th position. My life could have taken a turn for the worse, but especially with my very playful character in my younger years, but for the discipline instilled in us by our parents. May they find rest in the bosom of the Lord. I must give special thanks to our indefatigable, hardworking, dynamic, result-oriented Vice Chancellor, Professor Ekpoma, who has positively transformed and redefined university admission since he took over the reins as the Vice Chancellor of this great University of Benin. My special thanks go to the DVCs, the registrar, the bursar, the librarian for their support in the execution of various assignments given to me by the Vice Chancellor. I must thank former Vice Chancellors, Professor Richard Anao, who was the one who employed me as a senior lecturer in 2003. Former Vice Chancellor Sayuki Oshodi, who promoted me to the ranks of associate professor and professor. Let me use this opportunity, I don't know whether I'll have it next time, to thank former registrar, Mrs. Oshodi, who was of, please, can you stand up for recognition? Thank you very much. Who stood by me through thick and thin when I was the Dean of the Faculty of Law. There was no request that passed through her that she didn't attend to promptly. In fact, I always walk straight into an office, give her the papers, she treats the papers, and I go away. Thank you very much. I must thank former Vice Chancellors, Oruwese and Lillian Salami, under whom I served as two-term Dean of the Faculty of Law. My appreciation goes to the late Professor Akintunde Emiola, who fortuitously, without my desire, employed me as an assistant lecturer in 1990. Then I was looking for all those big jobs that my hand could not get to, in the oil sector, in the banking sector, and all that. But since he employed me in 1990, I have not looked back. I give God the glory. I must thank Professor D.Y. Hay, former Dean of Law and former Vice Chancellor, former Acting Vice Chancellor of Benin State University, who took me under his wings after my employment in 1990. I must thank Emeritus Professor Friday Okorofa, who has been a mentor to me. I must thank him for broadening my horizon. Special thanks go to Professor F. Okeme for his constant support and guidance since my days as the Dean of the Faculty of Law. It appears he has sneaked out. I saw him seated at the back there a few minutes ago. I must thank, for once or time, thank all the professors in the Faculty of Law. You all mentioned them, led by Professor Lawrence Asekwa, Senior Advocate of Nigeria. Thank you all. I thank the other academic staff in the faculty. Thank you very much. That will not permit me to mention every one of you, but I recognize you all as an integral part of my academic odyssey. I also acknowledge the cooperation of the non-academic staff of the faculty. You are no less appreciated. I thank the 360th Inaugural Lecture Project team, led by Dr. Anwulufani Sokolo, Dr. Juliet Ameroye, Dr. Adiza Akurobo, and Dr. Elizabeth Iyamojo, the last of two who are my mentees. I thank also the Dean of the Faculty, Professor Bright Bazaye, and former deans, including myself. Yes, so let me thank myself also for providing the right academic atmosphere and for me to thrive as an academic staff. I must thank the project team of SERI who have supported me since I've appointed the project center leader, led by the irrepressible Dr. Mrs. Vivian Ono. Yes, okay. I thank Mrs. Amber Otika Odibi, who has been like a mother to me since I got to the faculty. Thank you very much. I thank all professors, both within and outside this faculty. You all mentioned there, you see your names there. I can see some of you here. Thank you so much. And now, my family. I thank my nuclear and extended family for their presence here today. Particularly, I appreciate my siblings who are here today. I appreciate the matriarch of the INEGBEDION family, Dr. Jane Heye, who is here today. I thank you all for coming from far and near. I do not take your love for granted. I appreciate my children, Julius, Ofure, Osebuja, Odianosa, and Inome. But can you stand up for recognition? For their understanding and patience during my period of absence from home. My life revolves around you all. Now away with the suspects. I have to thank the wife of my youth, my better half, my life partner, the one who has been on this journey with me for over 30 years, my one and only, my darling, the one that has accommodated me with philosophical calmness in spite of my imperfections and has created the right atmosphere for me to thrive academically and professionally. With great personal sacrifices and without complaining. I appreciate all that you have done. And I feel you, my wife, Barrister Mrs. Inegbedion. Over the years, my profound love for you remains untainted, undiminished, unblemished. Till death do us part. Amen. Mr. Vice Chancellor, this is my brief. My debt is paid. Thank you all for giving me your attention.
360th Inaugural Lecture, delivered calmly and articulately. Please put your hands together. May I now respectfully invite the Acting Vice Chancellor, Professor Ekpoma, to recap the lecture.
Thank you very much. Let's appreciate this, our inaugural lecturer again. Thank you very much. Professor Inegbedion, congratulations. This is the recap of the inaugural lecture eloquently and intelligently delivered by our own Professor INEGBEDION. This is the synopsis of the lecture. The lecturer began with an expose on the utilitarian school of law by asserting that the role of law is to promote happiness. And in that sense, the primary goal of every constitution should be to promote pleasure and reduce pain. The lecturer posited that constitutions can only do so if they are transformative. That is, there must be in place a system of constitutional enactment, interpretation, and implementation or enforcement. In this respect, Professor INEGBEDION explained certain key concepts such as utilitarian school, transformative constitutionalism, and good governance. From the contextual angle, the lecturer identified certain key transformative features of the Constitution, but expressed some reservations from the perspective of its interpretation and implementation. In this sense, the courts must play a central role. The issues raised in the lecture focused on certain aspects of the Constitution, such as the federal design, fundamental objectives and directive principles of state policy, justiciability, local standing. The court's role in this respect largely fails to enhance transformative constitutionalism. The lecturer provided a nexus between transformative constitutionalism and good governance using a basket of countries, including Nigeria. The lecture showed that why the countries compared with the qualities of transformative constitutionalism in terms of a system of constitutional enactment, interpretation, and implementation, particularly as it relates to human rights protection and local standing. This has negatively impacted good governance and resonates with Nigeria's overall poor implementation of the Standard Sustainable Development Goals, SDGs. This is exemplified in Nigeria's last position amongst the countries compared in the Human Development Index, HDI, for 3 consecutive years, and encouraged constitutional irreverence. The lecturer recommended, amongst others, constitutional amendment to clearly delineate the place of local governments in Nigeria's federal design, adopt the indivisibility approach in the interpretation and enforcement of human rights, amend the Constitution to clearly adopt public interest litigation in human rights protection, and set up a constitutional court to promote transformative constitutionalism. Once again, I'd like to congratulate our erudite Professor Akabwe, for this very epic inaugural lecture that you have delivered today.
Thank you very much, sir. Please put your hands together for my acting VC as we invite the immediate family members to come up stage to support the lecturer. The Vice Chancellor will now decorate him. While that is being done, we would like to recognize the wife, Edna INEGBEDION Esquire. She's the Director of Administration, IRWA Specialist Teaching Hospital. Please put your hands together. The children are all surrounding him. Julius INEGBEDION Esquire, Jemima INEGBEDION, Nathaniel INEGBEDION Jr., Lawrence INEGBEDION, Christabel INEGBEDION. Please clap for them. Thank you. Other family members here are Mr. Matthias Omofoma, who is the uncle, Michael INEGBEDION, elder brother, Mrs. Rosalind Eromoseli. You are all welcome. We welcome very specially my Lord, the Chief Judge of Edo State, Honorable Justice Daniel Okungbowa. We welcome the following judges. Honorable Justice P.A. Ahiheru. Please encourage them, encourage them, encourage them. Honorable Justice VOA of Yahweh, welcome, sir. We welcome Igodalo Imadogbelo, SAN, welcome, sir. We welcome Kingsley Obamogie, SAN. Professor Lawrence Asengboa, SAN, we welcome you, sir. We welcome Professor Dominic Badaiki, SAN. We welcome Professor Emeritus Raymond Eliho. Welcome, sir. We welcome Professor Emeritus Julius Katua. Welcome, sir. We welcome the former registrar of our university, Mrs. Otasowie Oshodin. Welcome, ma. We welcome former librarian, Professor Luke Obasuyi. Welcome former Dean of Law, Professor Ikmonwosa Omowuyi. Welcome, sir. The University Orator, Professor Gabriel Riche, you are welcome. Welcome, Director of Enforcement, UNIBEN, Professor Richard Idubo, Professor Emeka Chianu, Professor Odion Odame, Barrister Joseph and Mrs. Mary Okobieme. Welcome, Professor Agatha Egwavoin, my big auntie. Please, if you are here, auntie, stand for special recognition. Is she still around? Okay. Thank you, Prof. Welcome. Please clap for her. That's my big auntie at Ekpoma. Thank you, ma. So we also welcome Professor Osanyamo Egwavoin. Welcome Director of Servicom, Professor Cyprian Oshoma. Welcome Professor Patience Orupe, Professor Sunday Igbinosa, who this afternoon emerged Dean of Management Sciences. Congratulations, Prof. We welcome Professor Gideon Emelue. We welcome Professor Evelyn Umemezia. Professor Victoria Onuoha. We welcome you, ma. Welcome Professor Eunice Eragbe. Welcome Professor Osaitin Aigbavo. Welcome, sir. We welcome Honorable Justice Edoro Eboigbe. Welcome, sir. We welcome former Dean of Law, my special lady, Professor Violet Aigbokairo. I saw that coming. We welcome Professor Eric Okoje, Professor MP Ezekiel. We appreciate you for coming, Professor Angela Oriazowana. Welcome. Professor Matthew Olong, Professor Odion, Professor Mrs. Esewe, Professor G.L. Umoru, former DPP, that's Director of Physical Planning, former Architect Timi Ikesimoje. Welcome, sir. Welcome Chief Percy Okoje. Welcome Mr. Nidu Ine. Welcome my own dear cousin. We welcome Sir Professor Emmanuel Akigbe, Esquire. Welcome. Acting Vice Chancellor, sir, distinguished ladies and gentlemen, that's how we come to the end of this very interesting 360th inaugural lecture of the University of Benin. But just before we go, please rise for the UNIBEN anthem and then the national pledge. pledge to Nigeria, my country, to be faithful, loyal, and honest, to serve Nigeria with all my strength, to defend her unity, and uphold her honor and glory. So help me God. Please remain standing while the Vice Chancellor's procession leaves the auditorium as I welcome very specially my own dear cousin, Prince Ekpoma Akenzwa. Welcome.